What if I told you there's a law written 200 years ago that secretly shapes your life every single day? It's not something you learned in history class, and most lawyers probably don't even think about it. But this forgotten piece of legislation, born in the 1820s, has an invisible grip on modern America, influencing everything from the products you buy to the rights you hold dear. Today, we're pulling back the curtain on this 200-year-old legal mystery. Why is a law from the age of horse-drawn carriages and candlelights suddenly making headlines in the 21st century? Stick with me, because the answer will change the way you see the world around you. Let's travel back in time. The year is 1823. America is a young, scrappy nation, still figuring itself out. James Monroe is president. The western frontier is a wild, untamed expanse, and the Industrial Revolution is just a whisper on the wind. In this era, Congress passed a law. It wasn't a headline grabber at the time, just one of many statutes designed to manage the growing pains of a new country. It was created to solve a very specific 19th century problem, dealing with things like river navigation, trade disputes between states, and property rights in a pre-digital world. For decades, even centuries, it did its job quietly in the background, and then, like many old laws, it faded into obscurity, buried under layers of new legislation. It became a relic, a footnote in dusty legal textbooks. But here's where it gets interesting. Laws don't just disappear. Unless they are officially repealed, they remain on the books, waiting. And this particular law contained language so broad, so foundational, that its potential reach went far beyond what its creators could have ever imagined. It was a legal time bomb, ticking away silently for 2 centuries. So, what exactly is this law? Let's call it the Foundational Commerce Act of 1823 for our purposes today, as its real name is quite dense and legalistic. At its core, this statute was designed to establish a clear, unified framework for how goods and services moved across the newly forming United States. Before this, states often acted like separate little countries with their own conflicting rules, taxes, and regulations. It was chaos. If you were a merchant trying to ship grain from Ohio to New York, you might face a dozen different hurdles. The 1823 Act was meant to streamline all of that. It established that certain fundamental principles of trade, contract, and liability would apply universally, creating a truly national marketplace. It was a revolutionary idea, and it helped power America's economic engine for the next century. But the architects of this law used incredibly forward-thinking, principled language. Instead of listing specific goods like cotton or timber, they wrote about articles of trade and commercial instruments. Instead of just talking about riverboats, they defined principles for interstate conveyance. This abstract language is the key. It allowed the law to be flexible, to adapt. But no one could have predicted just how much it would need to adapt. For over 150 years, the law was mostly dormant. The courts relied on newer, more specific legislation to handle modern problems. The Sherman Antitrust Act, the Food and Drug Act. A whole library of 20th century regulations seemed to make the old 1823 statute obsolete. It was like having a horse and buggy in your garage after you've bought a sports car. You know it's there, but why would you ever use it? Legal scholars considered it a historical artifact. But in the late 20th and early 21st century, something changed. A few brilliant, and perhaps a little eccentric, legal minds started digging through the archives. They were looking for new solutions to complex modern problems, problems that newer laws weren't solving effectively. And they stumbled upon this sleeping giant. They realized that the broad, principled language of the 1823 law wasn't a weakness. It was its greatest strength. It wasn't tied to steamships or telegraphs. It was tied to fundamental principles of justice and commerce. And those principles, they argued, were timeless. This brings us to today. So why is a 200-year-old law suddenly causing a stir in 2023 and beyond? The answer lies in the digital age. Think about it. the internet, cryptocurrency, artificial intelligence, data privacy. These are concepts the 1823 Congress couldn't even dream of. Our modern legal system is struggling to keep up. Lawmakers are scrambling to write new rules for a world that changes every 6 months. But what if the foundation for those rules was already written? That's the explosive idea gaining traction right now. Legal pioneers are arguing that the core principles of the 1823 Act can be applied to the digital marketplace. Is your personal data an article of trade? When a company in California sells a digital service to someone in Florida, does that fall under interstate conveyance? Can a smart contract on the blockchain be considered a commercial instrument? These aren't just academic questions. They are at the heart of major court cases being fought right now. Let's look at a concrete example. Consider the debate over big tech and monopolies. Current antitrust laws, written for industrial giants like Standard Oil, are often clumsy when applied to companies like Google or Amazon, whose power comes from data and network effects, not just physical assets. But some legal teams are now making a novel argument. They're citing the 1823 law. They argue that the law's original intent was to prevent any single entity from unfairly dominating trade routes and choking off competition, whether that trade route is a river or an internet search algorithm. By framing the issue in this way, they are forcing courts to look at the problem from a completely new and yet very old perspective. This isn't just about tech. Similar arguments are popping up in environmental law, with lawyers suggesting that the long-term health of natural resources like clean air and water, which cross state lines, falls under the protective umbrella of this foundational statute. It's being used to challenge unfair business practices, to protect consumer rights in online transactions, and even to debate the future of remote work and cross-state employment law. This forgotten law has become a powerful, versatile tool, a legal Swiss Army knife for the 21st century. So what does this all mean for you? On one hand, it's a testament to the enduring power of good legal writing and foundational principles. It shows that justice isn't always about creating brand new laws, but sometimes about rediscovering the wisdom of the past. It offers a potential pathway to solve some of our most complex modern challenges by standing on the shoulders of those who came before us. However, there's also a debate to be had. Critics argue that using a 200-year-old law in this way is a form of judicial activism, stretching the original intent of the lawmakers to fit a modern agenda. They worry that it could lead to unpredictable legal outcomes and create instability. Is it right to apply a law written for a small agrarian republic to a global digital superpower of 330 million people? That's the billion-dollar question being debated in courtrooms and law schools across the country. The battle over the interpretation of this 1823 statute is really a battle over the future of American law itself. Will we be governed by the precise letter of modern regulations or by the broad, timeless principles of our oldest legal foundations? The legacy of this once-forgotten law is still being written. Its resurgence after 200 years is a powerful reminder that history is not just a story of the past. It's a living, breathing force that continues to shape our present and our future. It proves that sometimes the most innovative solutions can be found by looking backward. This obscure statute from 1823, created to solve the problems of its day, has inadvertently become one of the most relevant and hotly contested legal documents of our time. And its journey is far from over. The next time you hear about a landmark court case involving technology, the environment, or consumer rights, listen closely. You might just hear the faint, 200-year-old echo of this forgotten law, still working to ensure justice in a world its creators never could have fathomed. What do you think? Is it brilliant legal strategy to revive old laws for modern problems? Or is it a dangerous game? Let me know your thoughts down in the comments. I'm really curious to hear your perspective on this. Thanks so much for joining me on this deep dive into a fascinating piece of legal history. If you enjoyed this journey and want to uncover more hidden stories that shape our world, be sure to hit that like button and subscribe for more content just like this. See you in the next video.